Okay, good evening, folks. Welcome to Monday Night Live with just me. It's episode 2. I'm going to teach you a little bit about status, standing, and jurisdiction, and how to write some basic documents here in the beginning. So, let some people get on here. Hi, Chad. Hi, Rosa. Hi, Brenda. Hi, Barb. All right. So last week, I went over some basic stuff, foundational stuff of law, of what your rights are and where they come from in law. And there's a document here that we need to go over because that's your status and standing, essentially. It's the Declaration of Independence. And there's a couple other things that needs to be added to that, but you can use the entire Declaration of Independence, right? Christopher Hallett, in his Practitioner's Judicial Report, the Declaration of Independence is actually in that Practitioner's Judicial Report, which everybody can use that whole report as it is, right? Because it's written by a practitioner, and practitioners are the experts on their in their field. When those experts write their documents, they're called practitioners' reports. So that's a practitioner's judicial report from E-Clause. And they're well aware of that sucker by now. So when you attach that to any of your documents, it's an expert on the law that tells them what the law is, whoever reads it, whoever's reading your documents, right? So if you haven't had a chance to get that, that's in Kirk's Law Corner group. It's in the formerly known as Amber and Stephen group. It is now E-Clause LLC group. It's in the files section. So that's something you can attach to any of your documents and give reference to it, especially the negative nexus, which I call the Hallett doctrine. That is -1 times a -1 equals 1. And Chris has done several videos on that negative nexus, but one of his recent ones there just the other day is one to watch. So I haven't actually had a chance to watch it yet from the beginning. I actually came in real late and watched, participated in the last like 10 minutes of it, so I missed all of it. But Chris said that's the one that he was teaching on that. So that's one you'll want to go watch. Now, if you haven't had a chance to watch the first episode, you're going to want to go back and watch that so you get the foundation here. Where your rights come from? What are your rights? Where do they come from in law? And you're going to have to do some reading. And if you can't commit this stuff to memory, write it down a few times, something, whatever it takes for you to commit this to memory, because you need to be able to rattle this stuff off, right? Anywhere, anytime. If you get in a jam and you're locked up, okay, you're going to have to be able to go from your head and write this stuff down on a piece of paper, right? I know that's a lot to ask right at this particular moment, and probably more than some of you will ever be able to do, is be able to commit this stuff to memory and rattle it off when need be. But it's something that I highly suggest that you train your mind to do. And it takes repetition, some more than others. Okay. I don't expect you to be able to rattle off like me, where I've been doing it for 24 years. So that would be an unreasonable expectation to put on anyone else. But thank God for the brain he granted me with, blessed me with. I read stuff and I comprehend it, and a lot of it just goes right to memory. So all right, let's see. Let's go with the Declaration of Independence, which is pretty much where I left off. This is going to start out with your status, right? I mean, what does it say in that Declaration of Independence? This is what you need to know, right? Let's see. Alt F, we'll go independence. There it is, Declaration of Independence. I was going to pull this up too. That's right. So I can see comments. Actually, I forgot to tag myself. Let's go there. Okay, here we go. The Declaration of Independence. Okay. Hi, Valerie. Hi, Kathy. Hi, Susan. All right, do some screen share here. My favorite site here, avalon.yale.edu or avalon.law.yale.edu. So this is from Yale Law School, right? It's supposed to be the one of the fancy ones. When we're reading this, when in the course of human events it becomes necessary for one people to dissolve the political bands which they have connected them with another, to assume among the powers of the earth, not the power of man, but the powers of the earth, right? The separate and equal station to which the laws of nature and nature's God entitles them. There's your part of your status, right? Where do your rights come from? They come from the law of nature, from nature's God. And we are entitled to those rights. No man can interfere with those rights. Okay? A decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. We hold these truths to be self-evident, right? Should be self-evident when you say this, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, certain ones, that among these, that does not mean all of them, these are just certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. So, your status is a creation of God with certain creator endowed unalienable rights. Among these rights are life, liberty, property, and the pursuit of happiness. There it is in writing right there. And you reference the Declaration of Independence. In fact, I highly recommend you copy and paste the entire thing into any document that you're going to refer to, so that they know where in law, as it was laid down, because declarations lay down the law. That was in episode 1. So that's it right there. There's your status, right? You're a creation of God, pursuant to the laws of nature, power of the earth, right? Nature's God entitles us as a creation of God. These are our basic fundamental rights. It's not all of them, because that's just among them. But there's a lot that comes under liberty, like personal liberty. Personal liberty consists in the power of locomotion. Okay? To go wherever your internal dictates of your mind dictate to go. Wherever you want to go. That's your constitution. Okay? The constitutions are for what? That's for creating the form of government, and those that want to serve the people are to be bound by those constitutions. But our constitution is the internal dictates of our mind. So we have that right to claim that through this right here. Okay? That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That means we are self-governed. Our Constitution dictates our rights, our actions, right? So this is what you could tell them right there. Well, you're instituted among men here. Government really doesn't exist. It's a figment of the imagination. These constitutions are in writing, but that's for the public servants to serve the people, and the process for bringing them into being. And then the Bills of Rights, which is always the first article of every state constitution, and the Bill of Rights, those are merely declaratory of the common law. That's the rules of the common law that the Seventh Amendment is talking about. Pursuant to the rules of the common law, that's what they're talking about in the Seventh Amendment. What's in Bills of Rights? Those are declarations, Declaration of Rights. Okay, that's the law of the land. The law of the land dictates the process, not statutes, codes, and city ordinances. The law of the land dictates, but only in that jurisdiction. And I'll get into that, and that's where we're going to be challenging jurisdiction. I'm going to show you how to write that document. Okay. I know there's people out there that have these lengthy documents, and it's made out to be a lot more complicated than it actually really needs to be, right? These are very simple, short, and sweet demands. And one thing we need to get out of our head here is, oh, I got to make a motion. Nope, not pursuant to the common law. I'm going to teach you the common law way of doing things. We make demands, right? I demand you get off my property. Property is a what? An aggregate of guaranteed rights. So when somebody trespasses upon your unalienable or unalienable rights that are come from God, they're trespassing on our property. And I'm making the demand you get off my property. You stop depriving me of my property without due course of law or due process of law, the law which comes from the law of the land. You're not following the law of the land, then you're trespassing the law. You're trespassing on my rights. I don't take very kindly to somebody trespassing upon my property. I do have the right to defend my life, my liberty, and my property as I see fit. Okay, so in here, that whenever any form of government comes destructive of these ends, it is the right of the people to alter or to abolish it and institute new government, laying its foundation on such principles, right? And organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Prudence indeed will dictate the governments long established should not be changed for light and transient causes, which is where we're at right now. Okay, our form of government, the way it's laid down, ordained, and established, is beautiful. It's awesome. There's only just a couple of things that I would maybe make some changes on, but other than that, generally speaking, the way the constitutions are laid out, it's pretty damn good. So I don't want to actually change our constitution now, our form of government now, but that's what they were doing then. Remember? Political separation, dissolving the political bands with the crown. Great Britain, that would be the Lees Resolution, June 7th, 1776, and ratified July 2nd, 1776. You'll notice this is July 4th, right? The Lees Resolution was ratified on the 2nd. That's actually the document that moved everybody from Great Britain as colonies underneath the law of Great Britain and the political power of Great Britain, and separated us, and it created individual sovereign states. The status of the people in society created individual countries. In order to form a more perfect union, right, we did this. This is part of the declaration of why we are now independent, because as it says down here, to prove this, let facts be submitted to a candid world. Okay, and what's going on here was the history of the present king of Great Britain is a history of repeated injuries and usurpations. Okay, all having in direct object the establishment of an absolute tyranny over the states. To prove this, right, let these facts be submitted to a candid world. He has refused his assent to laws the most wholesome and necessary for the public good. Let's see, there's some really good ones that are just going on today. And like Chris says, you know, what they've done is they've used the Declaration of Independence, these declared acts of tyranny, as a checklist. And they're doing exactly the opposite of what's in the Declaration of Independence, for depriving us in many cases of the benefits of, notice that it says trial by jury. It doesn't say jury trial. Our right is a right to a trial by jury. This is where we get into that word salad, and they're trying to change the definition and what a trial by jury actually is, which I showed you in episode 1 last week, that how a trial by jury is supposed to work. Of 12 men of your vicinage, without whose unanimous consent cannot be deprived of his life, his liberty, or his property. That's that unanimous consent, beyond a reasonable doubt. They try to tell us today that, oh, well, if you don't, it's got to be either unanimous not guilty or unanimous guilty. No. You have to have consent to find me guilty, and you have to have consent from all of them. If you have one that says, you know what, I'm not buying it, I just don't feel right, I don't think it's right, you lose. There's no retrial. There's no such thing as a hung jury. That's not how the right works. The burden of proof's on the moving party. That's just the way it is. That's how the right dictates. That fundamental law, the principles, the common law, dictates how that right works. And no man can change that. Not even a little bit. So this is where you have to know what it says in the Virginia Declaration of Rights as it is written, so that you can properly quote it, right? How about for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our government? That's exactly what they're doing. Where's the common law courts dealing with our common law rights? We're being subjected to a jurisdiction that's foreign to our form of government. It's called bills of attainder. That's what this is all about right here. That's part of it. Same thing with this here. For abolishing the free system of English laws, the neighboring province, establishing therein an arbitrary government, and enlarging its boundaries. What do you think they're talking about there? Enlarging its boundaries of jurisdiction, so as to render it once an example and fit instrument for introducing the same absolute rule into these colonies. It's exactly what we're talking about. Extending admiralty and vice admiralty jurisdiction beyond their ancient limits. There are 3 testimony trusts out there. Okay. Land, air, and water. We're on the land. We go by the law of the land. That's the way our founders set up our form of government, as a republic. We are not a democracy. We're not a monarch. We're not an aristocracy. We're not a fascist, socialist, communist, totalitarianism form of government here. This is a one-of-a-kind form of government in the entire world. There is absolutely no other form of government in this entire world that is a republic where they are self-governed like we are. They have some sort of dictator in chief up there. Even the best of them are not a constitutional republic. A lot of people try to say, well, the Constitution is a living document. Really? When's the last time you've seen the Constitution get up and walk around? It was put in writing by our founders on purpose so that no man can, misunderstand it or misconstrue it. Oh, well, the judicial branch has the power to interpret that. No, you're the law sayer. You speak the law as it is written. There is no man out there to interpret anything. You can't comprehend the English language, then you have no business even trying to do anything with law, right? You can't read this stuff, comprehend it. Don't let them try and interpret it for you. You tell them what it says. And not only that, Constitution doesn't apply to us, right? We're not the ones that are bound by it. We're the free people. That's why we go off of the common law. Rules of the common law come from the Bills of Rights. I showed that last week. That would be American Jurisprudence, Volume 16, Constitutional Law, Section 100. How about for suspending our own legislatures and declaring themselves invested with the power to legislate for us in all cases whatsoever? That would be a declared act of tyranny, wouldn't it? Self-evident that the legislature does not have the power to legislate for us in all cases whatsoever. We have the common law for a reason. That's the reason why the common law was laid down before the Constitution was created, before our form of government was created. Our founders laid down the law. So we don't go by the Constitution. We, the people, go by the Bill of Rights, all of them. Now, there are certain things in the Constitution that tell them, like Article 4, Section 1, full faith and credit given to the public acts, right? What is a public act? Well, Idaho here, I have my organic act of the territory of Idaho. That's the organic law, the law of its creation. Okay, all the basis for creating Idaho is in that organic act. That's the organic law. That's the law that creates Idaho. And if we're going to create something, you have to lay down the law of its creation, right? Succession of law of creation here. So knowing some of these declared acts of tyranny will behoove you and help you behoove you to read them and comprehend them, right? So where is it? We therefore, the representatives of the United States of America. So anytime you're writing something, don't forget to put of America, because America is the nation. The law of the nation, the law of nature applies. When you say the United States, talking about the federal corporation, you don't want to talk about the federal corporation. You want to talk about the American Union, right? These states that have united together in the nation called America. Appealing to the supreme judge of the world, we're talking about God, for the rectitude of our intentions, do in the name and by authority of the good people of these colonies solemnly publish and declare that these united colonies, united colonies are, and of right ought to be, free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved. This gets rid of everything from Great Britain. From this day forward, technically the 2nd, July 2nd, because that was the Lee's resolution that did this. That's the document right there. coupled with this tells them, no, Great Britain, get out of here. Anything from the British Crown, Great Britain, the whole 9 yards is not valid here. And that as a free and independent states, they have full power to levy war, conclude peace contract alliances, establish commerce, and do all other acts and things which independent states may of right do. And for the support of this declaration, with a firm reliance on the protection of divine providence, we mutually pledge to each other our lives, fortunes, and sacred honor. So, there was another part here, I thought. Maybe it's back up here and I just missed it. But when a long train of abuses and usurpations are invariably the same arguments is designed to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security. Now, in our Constitution, we have the right to impeach these guards, these bad actors in government, and remove them from duty. And that's not something I'll be talking about tonight, document-wise. Trying to teach you foundation stuff here, basic fundamental stuff. The stuff you need to know in the beginning of your case, okay? Or at any time in your case, you can do this. So I know they will try to hem-haw about it, but you need to understand, comprehend that you have not only the right, right? Not only is it a right, but it's a duty to throw off such government and to provide new guards for their future security. You can claim that right here, as it is written in the Declaration of Independence. Okay? So that's in the First Amendment, the Bill of Rights. We have the right to petition government with grievances. And in my state constitution, it's Article 1, Section 10. We have the right to petition the legislature, not the judicial. Okay? We got to unbrainwash ourselves here and retrain our brains to go into the legislature with our grievances, with our petitions of remonstrance. Okay? Got to retrain ourselves. So there's part of your status and standing in law right there. That's your Declaration of Independence. It says where your rights come from as creation of God, right? Let's see. I'll bring up mine. Let's see. What? Oh, wait. Is it this one? Opening it up my document here. Yes, close. I suppose we could go over here, go into, I'll just take you right into my own rules of procedure here. So it's not like I'm making this stuff up. And here's the thing is we need to comprehend here is at the root of all of this stuff is the common law. Because you cannot get away from the common law. Plain and simple. Pleadings in practice, right? But at the common law, we don't plead with anything. We demand. So let's see, rules of civil procedure. I believe it's 4.1. Yep, 4.1. I'm going to share this screen share here so you get the idea that, not making this stuff up, at least in my state, in our rules of procedure. Rule 4.1, this is just the civil, right? Because this is a civil thing. General or special appearance. Okay. Motion or, so it's not a motion, right? Special appearance to contest personal jurisdiction. Right here in my own Idaho rules of civil procedure. Okay. This is supposed to be self-evident here. The following do not constitute a voluntary appearance by a party under this rule. Okay. A motion under Rule 12B 2, 4, and 5, whether raised before or after judgment. I'm going to take you to Rule 12 here in just a minute. A motion, but see, we're talking about motions. And so we're going to get rid of that word motion because that's the word salad they want you to play with, because that gives them jurisdiction to deny. You're telling them, well, I'd like you, I'm pleading with you, I want you to do this, I want to move the court this way, but no, that's not, we're not going to acquiesce to their authority, their color of authority, acting under color of law. So this notice of special appearance to contest personal jurisdiction must be done in the very beginning. Although that would be their deal there, and I think that we can still go back and do this. So what's the worst thing they're going to say? Oh, well, no, you can't do that. Screw you, I've just made my court of record. The court of record is nothing but documents. And so once you've made your court of record, you throw some rebuttal out there if you got it. If not, you better not even respond, which will end up what's going to happen. Okay, motion for extension of time to answer or otherwise appear. So in the event you get something and you didn't get your notice of special appearance done before you have to go in, then the thing to do is say, okay, I need a continuance, I need an extension of time to do my administrative duties under sui juris. Okay. Do not at any time try to answer anything. Well, how do you plead? How do you plead? Well, I'm gonna plead it. Plead, if we're gonna talk pleadings, I'm gonna plead in the form of demur, because I'm objecting to the personal jurisdiction here. I don't consent to this, and that's what the Declaration of Independence says, right? With the consent of the governed. I don't consent. You don't have jurisdiction. You don't have authority. I have to give my consent. Sometimes it's by accident through tacit or acquiescence, but nonetheless, you want to make sure that you say as least amount as possible so that you don't get trapped. You stick to the facts and stick to exactly what you need to say, and that's it. And there is the rule of 3 here. You have to repeat yourself 3 times, that's fine. After the 3rd time, obviously that man or woman up there in their disguise or whoever it is not of sound mind, because they can't comprehend you repeating yourself 3 times. Okay. So there it is. And it's a notice of special appearance, right? Appearing specially, not generally. And that would look like this. Okay, notice over here I'm in proprietary persona, sui juris, and in personam, And actually, I think I'm probably going to get rid of that. And actually, I could get rid of impropriety persona as well, because that's down in there. Sui juris is what you really want, because that's a man of lawful age, of sound mind, and perfectly capable of handling my administrative duties. That's this. This is your administrative duties right here. And the title of the document is Notice of Special Appearance. Okay. To the clerk of the above district court comes now one of the people of the state of Idaho, right? Because I'm one of the people, a man, right? Lawful father, this is for my family case here, but generally speaking, this is something that can be done in any case that you're in, right? And it's short and sweet, right? Appears specially and not generally in propria persona, which means I'm objecting to the personal jurisdiction. Okay. And then your next document, and I should do, this is before I knew about demand versus motion. And it's, you know, here I am, coming sui juris in propria persona as proper person objecting to the jurisdiction of the court pursuant to, and intends to give oral argument, which really, at this particular point, like I said, I wrote this before I learned about demands and the actual 3 testimony trusts. Okay. But here it is, right? Motion to dismiss. This is under family law, family rules of family law procedure. They've changed it from Rule 12 to Rule 502. But there it is, lack of subject matter, lack of personal jurisdiction. Okay. Demand for relief for an order dismissing. Okay. And basically, you're going to change this in here, or I would change this, knowing what I know now, is adding the fact that I'm going to demand that jurisdiction be proven. Jurisdiction must be proven once challenged, and it must be proven in writing and on the record. And then you got your little brief and memorandum in support of your motion dismiss or demand. Like I said, I'll be changing that stuff. And I think I actually have it in this one. Once jurisdiction is challenged, this process is no standing in law inside the borders of a state. Article 1, admiralty courts and tribunals are limited in their jurisdiction pursuant to Article 3, Section 2, Clause 1, Article 1, Section 8, Clause 2 and 17, right? Article 1, Section 9, Clause 3, 7, and 8, and Section 10, Clause 1 of the Constitution of the United States of America. Legislative branch may only create inferior courts under admiralty and maritime jurisdiction outside the borders of a state. Because that's what it says right here. Title 18 United States Code subsections 7 and 10, 2261, 2261A, and 2265, which this court claims full faith and credit. In the year 2000, the Supreme Court of the United States held that parts of the Violence Against Women and Children Act was unconstitutional as it violated the Commerce Clause and Section 5 of the 14th Amendment of the Constitution of the United States of America. Okay, that would be United States versus Morrison, 529 U.S. That was in 2000. When you go look up, this was on a protection order. Right on the front page of the document from the protection order says, well, that they took their full faith and credit from there, that 2261, 2261A, and 2265, they say that they took, that they have full faith and credit from there. Well, somebody obviously hasn't been keeping up with their court reports here, Because in 2000, we're talking now 2019, okay, somebody hasn't been keeping up with the court reports and told them that process can't be done like that, not inside the borders of a state, which I have it in here. The actors in the matter of no standing in the law cannot claim immunity from damages for fraud upon the court, claiming good faith reliance, full faith and credit, to issue this temporary ex parte protection order, because that process doesn't exist unless you have law enforcement support. It's a different story. Okay. Under estoppel means stop this crap because it was misrepresented. And I know that I have. Here it is. Okay. Corpus Juris Secundum, Volume 7, Section 4, Attorney-Client. The attorney's first duty to the courts, first duty is to the courts and the public, not to the client. And whenever the duties to his client conflict with those he owes as an officer of the court in administration of justice, the former must yield to the latter. Clients are also called wards of the court in regard to the relationship with their attorneys. That's a conflict of interest, confidence scheme, confidence scam, right from its inception. Stop hiring attorneys to attorn you. Okay? Corpus Juris Secundum parts as part of that will operate in a lawful manner. If the accused makes this assumption, he may learn to his detriment through experience that certain questions of law, including the question of personal jurisdiction, may never be raised and addressed, especially when the accused is represented by the bar. Right? Sometimes licensed counsel appears to take on the characteristics of a fox guarding the hen house. Imagine that. Jurisdiction, once challenged, is to be proven, not by the court, but by the party attempting to assert jurisdiction. The burden of proof of jurisdiction lies with the asserter. The court is only to rule on the sufficiency of the proof tendered. Here's those cases right there. All right, the origin of this doctrine of law may be found in Maxfield versus Levy. Right? So once jurisdiction is challenged, it must be proved in and on the record in writing. There's no ifs, ands, or buts here. And that a lot of times, which I've experienced, is the judge will say, well, I have jurisdiction here and I have jurisdiction there. No, no, no. You don't have any jurisdiction. None. You're not a party to the case. You're not the one that gets the choice of law and choice of jurisdiction. Okay? Here's some more points of authority. That's where I go to law.cornell.edu. This is the annotated Constitution. Special acts concerning claims. This clause enables Congress to pass special laws to require other departments of the government to prosecute or adjudicate particular crimes, whether asserted by government itself or by private persons. Congress adopted a joint resolution directing the president to cause suit to be instituted for the cancellation of certain oil leases, blah, 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 blah. This is just some weird stuff that I found in there. Basically, you just need to stick to the demand for proof of jurisdiction. Right? There's some other stuff out there aside from this one. But this, you know, that tells them, look, I'm demanding proof of jurisdiction. What is the name of the man who has standing in law to claim a right to a cause of action? Right? That's that probable cause that you're reading in the Fifth Amendment? That right to a cause of action, probable cause. Okay, you got to have a right. You have to be the injured party. Only the injured party can claim a right to a cause of action. Right? The state doesn't exist. It's a figment of the imagination. It's a dead entity. It's a corporation. It doesn't have standing in law. It doesn't exist in law other than being ordained and established to perform certain functions pursuant to the Constitution. And that's its limitations. It can't act outside of that. Corporations are dead entities. They can't stand, and they can't take the stand to speak. They can't testify to anything, right? Can't stand. If it can't stand, has no standing in law. They can't take the stand and speak. It has no standing in law. Plain and simple. Don't believe their crap. This is from the Law of Nations. This is one great one to have in here. The legislative power and whether it can change the Constitution. Here again, a very important question presents itself. It essentially belongs to the society to make laws both in relation to the manner in which it desires to be governed. Imagine that. That would be the Declaration of Independence, huh? As well as the Virginia Declaration of Rights. How we would want to be governed? Read that Virginia Declaration of Rights. Read the Declaration of Independence. Read the Articles of Confederation, because that's the stuff that says which way we want to be governed, or how we will be governed, as it is declared and laid down. And to the conduct of the citizens. Who are the citizens? We always seem to think that we're the citizens. And that's where that whole sovereign citizen crap comes in. No, 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 no. No, the citizens are the ones that are elected or appointed into a position of public trust. The ones that are bound by it, the Constitution, are the citizens of the United States. Right? Now we have things like natural born citizens, right? Now back in the day, technically speaking, yes, the people are both the people and citizens, but you don't technically become a citizen until you're appointed into a position of public trust or you're elected into public office, right? This is called the legislative power. That's that whole way society makes laws, both in relation to the manner in which it desires to be governed and to the conduct of the citizens. Okay? And we go by the rule of law in our republic. That's the difference between a democracy and a republic. And like Benjamin Franklin said, well, what's the difference? Okay, a democracy is two wolves and a lamb voting on what to have for dinner. A republic is a well-armed lamb objecting to the vote. In other words, rights can't be put to a vote. They're already part of the common law that was laid down before we created government. That's why at that time, our rights were supposed to be self-evident. SMU. Skateboarding like a mother Uber? Oh, stuff made up. That word salad. Break out that word salad shooter. So, let's see. The nation may entrust the exercise of it to the prince or to an assembly. So the way we look at this today, because this was written just prior to our creation of our nation. This is what our founders went off of, the Law of Nations written by Amr D. Vattel. Okay, the verbiage that we find in this Law of Nations, and this is used by our founders. The verbiage that's in here is what you'll see in our constitutions and the declarations and that kind of stuff. So the prince technically would be in our form of government like the governor, and the assembly would be the House and the Senate, right? See, jointly. So in the way our founders put in like triple protection. It's got to go through the Senate, then it's got to go through the House, then it gets put to the governor, and the governor has the power to veto it with his objections and send it back down, and then the House can vote on it again, right? Without the objections, they can pass what, minus the objections, they can pass what they want in their bill, right? So long as they have the authority, which is what we're going to get into right here. It says that, or to that assembly and prince jointly, who have then a right to make new laws and repeal old ones. It is asked whether their power extends to the fundamental laws, whether they may change the constitution of a state. The principles we have laid down led us to decide with certainty, without a shadow of a doubt here, that the authority of these legislators does not extend so far, okay? Through dumbing down of the people, through our lack of education system and brainwashing us into believe that everything goes to the judicial branch when you got a complaint about something. No. The legislators do not have the authority to alter the fundamental law or the Constitution. Now, the Constitution of the United States of America does say in Article 5, through an Article 5 convention, a constitutional convention, and then and only then can they alter the Constitution. So there is something right there, right? And that they ought to consider the fundamental laws as sacred if the nation has not in very express terms given them power to change them. In fact, the First Amendment specifically says, Congress shall make no law. Now, I know it says respecting religion, blah, 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 blah. In short, that is American Jurisprudence, Volume 15, Civil Rights, Section 2. Natural rights and civil rights have nothing to do with the establishment, support, or management of government. In our form of government, that would be power retained by the people, and not even the people can alter the fundamental law. Fundamentally, right? We can provide further protections, but you can't alter 2 + 2 = 4. You would totally destroy mathematics if you attempted to destroy fundamentally what that plus sign dictates. And that plus sign dictates the correct answer every time. Unless you're not of sound mind and, don't possess logic and reason and can't come to a reasonable conclusion based in reality that 2 + 2 = 4, we're all going to know who the one that's insane is, right? Well, I don't feel that that's right. Well, Lady Justice doesn't care about your feelings, okay? We, the people, establish justice, and 2 + 2 = 4 on every day of the week, ending in Y, which is all 7 of them. Every day, all day long. 2 + 2 = 4, no matter what you feel, your friend feels, or however you want to try and construe it. Yep, Susan, maxims of law, there's a ton of them in Black's Law Dictionary. In the later ones, they actually put them all together in the back, so it makes it kind of convenient. Some of the earlier versions, they're just right through the whole book. So when we're talking about maxims of laws, those are principles. They're maxims of law. They are the rule of law. They rule law, right? Like what I cannot do in my person, I cannot do through the agency of another. That's a maxim of law. If I can't do it, I obviously cannot delegate some power that I do not possess first to anybody else, whether they're in government or not. Not in our form of government. Thank God. Now what we have is usurpations of power. People acting in treason. Treason against the people of the United States of America. Treason against the Constitution. Giving aid to our enemies. Our declared acts of tyranny are known to tyrants. Tyrants are our enemy. They're an enemy to liberty. Therefore, that is a declared act of treason Okay? Again, that the authority of these legislators does not extend so far. And that's what we talk about, here in this legislative Mason's Manual of Legislative Procedure. The 10 principles, the first one being the group must have the authority to take the action it purports to take. Jurisdiction must be given. It cannot be assumed. Groups sometimes assumes powers they do not have. So obviously they're admitting right in the first principle that sometimes it happens. It's without a doubt that sometimes corrupt people will assume powers that they do not have. It's a fundamental principle of legislative procedure. Number 9, there must be no fraud, trickery, or deception resulting in injury to another member. A person is entitled to the protection of the courts from injury through injustice by a body making a group decision, as in any other situation involving injury. Okay? Number 10, to be valid, any action or decision of a body must not violate any applicable law or constitutional provisions. The decision-making procedures of any body must comply with the applicable provisions of any local, state, or federal law. It is governed by any statutory or court-made law. Whoa. Court-made law, including provisions of constitutions and charters. They're actually charters of freedom, Magna Carta, Declaration of Independence, the charters of freedom. But see, sometimes groups, groups sometimes assume powers that they do not have. Whoever wrote this Mason manual and wrote these 10 principles obviously assumed a power they don't have by saying that it is governed by any statute or court-made law. In our form of government, we have a separation of powers. The judicial branch doesn't have the power to make law. Neither does the executive branch. Only we, the people, have the power to make law. Because it says all political power is inherent in the people, not government. You only have the power to make policy, public policy. That policy only applies to the members of McDonald's, members of the state that are bound by it, bound by oath or affirmation to support this Constitution, right? All right. For the Constitution of the state ought to possess stability, and since that was first established by the nation, which afterwards entrusted certain persons with the legislative power, the fundamental laws are accepted from their commission, because that's the law of creation. We create the fundamental law, the common law, before we created the Constitution, which creates their position in government. Right? How is it that under the law of creation that the masters create the servants' positions, and then how is it the servants in those positions have the authority to dictate the law to us, the masters? They don't. It's completely illogical. That's like a McDonald's employee telling the CEO of McDonald's what he can and can't do. I don't think so. You'll get fired real quick. You try that crap with the boss, right? As it says here, right? It is visible that the society only intended to make provision for having the state constantly furnished with laws suited to particular conjectures, subject matter, and for that purpose gave the legislature the power of abrogating the ancient civil and political laws that were not fundamental. Fundamentally, we have the right to contract our labor as we see fit. Fundamentally, we have the right of personal liberty. There you go, Chris. Personal liberty consists in the power of locomotion. Choo-choo, vroom, vroom, right? Because that's personal liberty. That would be among those unalienable or unalienable rights. And you cannot convert any of those rights into a privilege, license them and turn them into a privilege, and I don't know, charge a fee for that? I don't think so. You cannot convert my right of personal liberty to go wherever I want to go, however I see fit, through the normal conveyances of the day, because that becomes personal property. My automobile becomes my personal property, and I have the right to acquire, possess, and utilize my personal property how I see fit, so long as it does not cause injury or harm to another man. We're good. And a license is seeking permission to do a thing otherwise would be illegal. Well, if it's completely lawful, why would I need to seek permission in our form of government, my neighbor, to first of all utilize my personal property how I see fit, to exercise my right of personal liberty, and to go wherever I want to go, uninhibited by statutes, rules, city ordinances, regulations, blah, 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 blah. Why would I need to seek permission from my neighbor to do that? Completely illogical. If my neighbor has the right to do it, why don't I have the right to do it? And governments, again, were instituted among men receiving their just powers. There was no power to alter the fundamental law. Fundamentally, we all have the right of life, liberty, and property. But nothing leads us to think that it meant to submit the Constitution itself to their will. In short, it is from the Constitution that those legislators derive their power, which is why I encourage everyone to read your constitutions, right? Supreme law of the land is actually our form of government. Article 4, Section 4, a Republican form of government. And not only that, the format, president, governor, House and the Senate, House and the Senate. Notice how it's identical? Some of the names change, but it's identical format, because that's how our form of government was laid down by law. We read the first Virginia Constitution, which would be June 29th, 1776, in conjunction with the Virginia Declaration of Rights, June 12th, 1776. You'll read in there how they established our government, how it's supposed to work. A lot of people aren't aware of that Constitution. And now they're trying to hide it even from Avalon. Okay, how then can they change it? If the Constitution, right, gives those legislatures their power, how then can they change? How can they change it without destroying the foundation of their own authority? So, this is Amergy Vattel from 1854 to 1774. How can you do that without destroying the foundation of their authority by saying, well, the Constitution says this is the power we have, but we're going to exercise this power to alter fundamentally our form of government and our fundamental law? No, you can't do that. Okay, England, the two houses of Parliament. So where did they get the two houses from, the House and the Senate? Right here. It's a great idea. It's 3 checks when you're trying to create legislation, because it's got to go through the House, it's got to go through the Senate, then it's got to go through the governor. That's 3 checks on something, right? That cannot be a bad thing. And at least 2 different sets of groups of people get to vote on that. Uh-oh. Come on. Not letting me do my thing here. There it is. Anyway, let's do back to that. Let's stop for just a second. What's going on here? I don't know why it's killing it. Here, let's do that. Oh, won't even let me remove you now, huh? All right, anyway, 3 checks are a good thing if the checkers have integrity. Yeah, that's why we have lots of them, right? They get to, it's supposed to be a 2/3 vote. Do we have a copy of the original ones? Neely, are you talking about the Constitution? I know that they'll have them in the archives down there. Let's see if this helps. No. I don't know what's going on here. Is everybody still receiving me out there okay? I know Zoom seems to be messing up here. There. A lot of trouble with voting is the next generation of voters are confused. Many don't. The Declaration of don't know the Declaration or Constitution. Okay, so everybody's hearing me okay. Okay. I didn't know if it started messing up over here. I don't know what's going on. All right, so let's go back to, I notice that I'm going through this document here. This is all, I put this all in like one document per se. So when it prints out, obviously it's 3 separate documents, but it's all put together in one. And so this is where we get into some really cool stuff with the section 30, book 1, chapter 3, section 30. This one's section 34, where it says, you know, of the legislative power, they do not have the power to alter the fundamental law, and they do not have the power to alter the Constitution. Technically speaking, the people in the state have the power to alter the Constitution through making amendments. That's the power of the people. So, number 30, of the support of the Constitution and obedience to the laws. Well, what are we talking about? Which laws? See, and this is where they pull the wool over the people's eyes. Okay? The Bill of Rights is the law, and the Constitution is the Constitution. It's trickery that they have put our Bill of Rights with the Constitution to give it the illusion and purport that the Declaration of Rights or Bill of Rights is actually part of the Constitution. Yes and no. The Bill of Rights, it's a Declaration of Rights, rights as law, right? That's the law of the land that we're talking about right here. We're not talking about statutes because we're not even supposed to have statutes, right? That's part of bills of attainder. Statutes that provide punishment. That's a bill of attainder. Bills of pains and penalties. In our form of government, we're not supposed to have those. Not applying to the people and purported as the Idaho Code, which is not law, by the way. The Constitution and laws of a state are the basis of the public tranquility. Well, who establishes the tranquility? Who establishes justice? We the people do, not government. And we do that before we institute government. Before, like it said, law of creation there, okay? The firmest support of political authority and the security of liberty of the citizens. But this Constitution is a vain phantom, and the best laws are useless if they're not being religiously observed. So this goes right to, if you don't know what it says as it is written, and you don't know how to claim it and properly exercise your rights, and how to effectively defend them, that's the vain phantom. You know, our founders in each state here did our constitutions for us, right? And is it all in vain if we're not reading it, not comprehending it, and not standing up? That's it. It's a vain phantom if we're not following it. If they be not religiously observed, we have to observe them. We have to assert them. We have to speak it and tell them, no, you don't have that authority. The nation ought to then to watch very attentively. I mean, that's very attentively. That's not like, just kind of pay attention. No. We're supposed to pay serious attention in order to render them equally respected by those who govern. That's right. And by the people destined to obey. So again, this is from the Law of Nations. It's all up to our founders, how they created our form of government and how that all works and applies. Well, to better secure our liberty, and especially the religious liberty, our founders created a form of government where the servants do not have the power to alter the fundamental law. Natural rights and civil rights have nothing to do with the establishment, the legislature, support, the executive branch, or management, the judicial branch of government. Not in our form of government. There's other forms of government out there that can do that. Heck, back in the old day, and still over there in the English common law, they use case law to make their law. Our form of government that we Brexited from there, those political separation, okay, we retained all the power. We don't allow government to alter fundamentally our form of government, to alter the fundamental law. Don't allow that. Not in our form of government. They knew better. So all power is inherent in the people, not government. Okay. Let's see. To attack the Constitution of the state and to violate its laws. Constitution of the state and to violate its laws. The Bill of Rights is a capital crime against society. Now, pay attention here. And if those guilty of it are invested with authority, they add to this crime a perfidious abuse of the power with which they are entrusted. Okay, so those of you out there trying to advocate for making 50-50 legislation for 50-50 custody, you're attempting to alter fundamentally the fundamental law through legislation, which we have not the authority to do. Not only the servants can't do it. We can't do it. We cannot alter that. Okay? Fundamentally, you cannot alter 2 + 2 = 4. But those who are in positions of authority, and there's a legal maxim out there, those with invested authority, the punishment should be doubled. Right? And that's what it's saying here. Invested with authority, they add to this crime a perfidious abuse of power in which with they are entrusted. The nation ought constantly to repress them with its utmost vigor and vigilance. As the importance of this case requires, it is very uncommon to see the laws and constitution of the state openly and boldly opposed. Not in 2019. It is against silent and gradual attacks that a nation ought to be particularly on its guard. They warned us before we even created the nation. In the law of nations, Amr D. Vittel is telling us to not be silent. Utmost vigor and vigilance. We got to be on top of this stuff, folks. Sudden revolutions strike the imaginations of men. What do you think Chris, John, and I are doing? Although I wouldn't say it was all of the sudden, but yeah, kind of was, if we're really talking about all of the sudden in the time span between 1776 and 2019, or 2017, when kind of started all this. They're detailed in history. Again, imagine that clear back then. They were detailed in history. Their secret springs are developed, tyrants. But we overlook the changes that insensibly happen by a long train of steps that are but slightly marked. Like, well, let's ban bump stocks. Let's ban certain weapons. Let's ban certain amount of rounds that you can have in a clip. That's exactly what we're talking about right there. Because what does the Second Amendment actually say? As it is written, what does it read? The right of the people to keep and bear arms shall not be infringed. What part of shall not and infringe do you not comprehend? No, you don't know, you don't comprehend the King's English, or what? Can't read and comprehend that stuff? Let's see. It would be rendering nations an important service to shew from history, to show how many states have thus entirely changed their nature and lost their original constitution. I can guarantee you right now, which is what I'm trying to get John to do, is go down, which he's doing now, is going down to his state archives and dig up the original act of the territory, Tennessee. Do this all in all of your states, right? And then the first actual constitution. And then you go through the succession of constitutions, and every time there's a change, they will print the new constitution, right? So what we need to look for is what was changed and who authorized it. Was it put to a vote by the people, or was it done by the legislature of the state? Because the legislature of the state clearly does not have the authority to alter the state constitutions. It has to be put to a vote by the people. And this is what's happened through time, is what we're being purported now. Here's my Idaho Constitution. This was published in 2017, was the last amendment that was put to a vote by the people, HJR 5. And so they had to reprint the updated version. Now we go back through history and we read all these and we find out, well, wait a minute. This wasn't done right. This wasn't done right. No, this is all void for any effect. Cannot do that. Right? That's why we have the supreme law of the land, Article 6, Clause 2. Anything in the constitutions, right? Anything in here, my state constitution, or laws, the Bill of Rights, to the contrary of the Bill of Rights, or other rights retained by the people through the Declaration of Independence, the Articles of Confederation, through the Virginia Declaration of Rights, through the Magna Carta, and all other treaties that have been made that declare Universal Declaration of Rights, blah, 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 blah. Anything that comes in conflict with that is not withstanding, pursuant to the supreme law of the land, right? So it's void for any effect from its inception, not from the day you go to court and brand it unconstitutional, okay? This would awaken the attention of mankind. Are we awake yet? We need to be. Impressed thenceforward with this excellent maxim, no less essential in politics than in morals. And it's principis obsta. I don't know, Chris, how do you say that one? Resist the first advances. Well, those first advances have been made a long time ago. We're getting down to the very tail end of Agenda 21 being implemented. Now they've got Agenda 2130, right? Or 2030. Because they're not going to get it done by 2021. And the more that we get educated and we wake up and we start doing these petitions of remonstrances into the legislature, which is saying, hey, this policy is bad. This policy is being implied as a force and effect of law on the people, and the legislature doesn't have that authority. Sorry, that's the wrong way. You don't have the power to make that kind of law that applies to the people. You only have the power to make public policy, public law. That policy only applies to the members of the agency so created. We need to resist those advances, right? We got to get in there, people. Which through inconsiderable in themselves may serve as steps to mount to higher and more pernicious enterprises. Law of Nations, Book 1, Chapter 3, page 93 through 96, Library of Congress, cataloging in public data. I mean, this is in there. It's already in our catalog as being part of our law of this nation, America, right? The law of nations, or principles of the law of nature, applied to the conduct and affairs of nations and sovereigns. What are we talking about there? The people are sovereign. The state, the people in the status of society are sovereigns, not the citizens. The citizens, again, are those that are bound by the Constitution. That's also from Amer D. Vattel in the Law of Nations, that the citizens are the ones that are bound by the Constitution, not the people, not the free inhabitants. We're not taking an oath and being bound by the Constitution. Although I did as a Marine, right? And under certain parts of the Constitution that I am bound by, right? The parts that apply to my contract that I made, which is to defend this nation from foreign and domestic enemies. Yes, we have domestic enemies, those who wish to do this slow encroachments and all that, those tyrants, capital felony treason, natural law and Enlightenment classics, includes bibliographical references. There's another book for you to read. Okay. Yeah, there's some more stuff in here. Did I put it in here? Yeah, here it is. One part of it. This is rights out of Beauvair's Law Dictionary. Rights might with propriety be also divided into natural and civil rights. But as the rights from which man has received from nature have been modified and acquired anew from the civil law, it is more proper, when considering their object, to divide them into political and civil rights. Although this would also be a scheme, scam, fraud, because natural rights are natural rights. They're creator endowed rights. But number 8 under the definition of rights in Beauvair's Law Dictionary from 1856, which is after 1776. Civil rights are those which have no relation to the establishment, support, or management of the government. These consist of the power of acquiring, enjoying property, right there, right? The power of acquiring and enjoying property, of exercising the paternal and marital powers, and the like. It will be observed that everyone, unless deprived of them by a sentence of civil death, it is in the enjoyment of his civil rights, which is not the case with political rights. That's the clear distinction here. Political rights have to do with who? Not aliens, not illegal immigrants. They don't have the political right to vote. For an alien, for example, has no political, although in full enjoyment of his civil rights. Okay? The court has trespassed the law. This is all my other stuff here. Here we go. This is something I stole from Supreme Court Chief Justice John Roberts explained, that it is best to regard the judge as an umpire. A good umpire does not care which side wins. And as long as the umpire makes the right process decisions in calling balls and strikes, people do not hold the umpire responsible for who wins or loses. This is where they have immunity. When they are making the right decisions, and they're only calling balls and strikes here. The second they act outside of their scope and authority as an umpire, they just lost all immunity. Ultra vires, Owen versus City of Independence, but you still have to go to the legislature to remove that immunity. That would actually be the sovereign citizen trying to claim sovereignty, which is what they do. Well, we have sovereign immunity. No, you as a citizen can't claim sovereign immunity. You can only claim immunity while performing your duties under your emolument that you were created, that seat in government that was created. That's an emolument, that seat in government, okay? So long as they're only calling balls and strikes, right? This is where I say that those judges up there are supposed to be the disinterested third party, not having a financial or otherwise equitable interest in the matter before the court, because that's not part of their scope and authority. We need to introduce documents that satisfy strict rules governing the admissibility of evidence. Our witnesses must be credible under cross-examination. We need to rebut any exculpatory defense evidence, and we must prove our case to the unanimous satisfaction of 12 random citizens. That's actually not true. They're supposed to be from our vicinage, people that know us and our character already. Now, he's lying here, but this is a quote. I'm quoting him from right here. We need to introduce documents. That's sui juris. Administrative duties. We have to introduce documents that satisfy strict rules of evidence. And I'm going to show you that here in just a minute. I've showed it before, but we're right here, so I'm going to show that to you, how to do this. But when you demand proof of jurisdiction, more than likely they're not going to respond, and they have 21 days to respond. Okay? So when that happens, you have to enter the judgment by default. If they don't respond, that's your documents are truth, facts, and evidence on the record. Anything left unrebutted becomes truth, facts, and evidence on the record. And this is where you become the moving party, right? The defendant, by pleading or exception, becomes the plaintiff. Well, you always want to be the moving party in any matter. Pursuant to the common law, we make demands for proof of jurisdiction. We make demands to know the name of the man who has standing in law to claim a right to a cause of action, right? What is his choice of law? That's juris. What is his choice of jurisdiction? The words of that law, right? And if you don't have that affidavit of truth from the move-in party, signed under penalty of perjury, and exactly what rights that you trespassed upon over there, and you caused injury and harm to them, there's no standing in law. And if there's no man to stand in law and claim that probable cause of action, the right to a cause of action, there's no jurisdiction here. None. I don't consent to that, and I ain't going to acquiesce to that crap. Perform your duties under sui juris and file your notice of special appearance, objecting to the personal jurisdiction. Do your notice, right? And then do your demand for proof of jurisdiction, and for it to be dismissed if it's not proven. So this is pretty much the end of the document here, from what I made quite a while ago. Well, that's another thing, Alan, is he says leave no rebuttal presumption. If you do not object, their BS will stand as truth. Here's the thing. You're not even responding to their claims yet. You're demanding proof of jurisdiction first, before I even respond to your claims. Okay? Before we get to this document, I want to take you over to the rules of procedure here. We'll go back to that. When you get into that, if there's a legitimate claim against you, right? And they can prove jurisdiction. It is the way it is. Okay? What? Or was that in? Oh, right. Let's see. Let's go back again to here. Family law. Okay. Remember we were talking about those documents in accordance with the strict rules of evidence. This is in the family law. Okay. 101, scope of rules, what they can and can't do. 102, rule number 2, rules of evidence, applicability. Upon notice to the court filed by any party within 30 days after a response or other responsive pleading is filed. So if in the event that you don't do the notice of special appearance objecting to the personal jurisdiction, and you legitimately want to fight this, you believe, especially if you're the moving party, right? and you want to try and go through this, or you're being subjected to this, you still can go back and object to the jurisdiction, but it's gonna be tough. But let's say where you are right now, in the middle of a case, and you want to go back. You're being served with something, whatever. Upon notice to the court filed, you have to file the notice, and it's a demand, right? Actually, this would be a notice that you will require strict compliance with the Idaho rules of evidence. Because if no such notice is filed, all relevant evidence is admissible. What did I just show you there? Only strict admissible evidence. This is backwards. I know it's backwards. I know it's backwards. But here it is. It's telling you. It's telling me here in Idaho. If not, then this admissibility standard shall replace everything. Right? Hearsay is admissible. Anything's admissible, pretty much. They just open the floodgates. Somebody wants to say something and puts it in writing, that's good. I don't care. No, I'm sorry. I'm going to require strict compliance with the rules of evidence. Okay? Now, oops. The first one. See that? Applicability of Idaho rules of civil procedure? Of course. The rules of civil procedure, that's where we were just at. So check this out. Rules of civil procedure. Let's go down to Rule 38 and 39. Notice it says jury trial here. Demand for jury. But then it says number 39, trial by jury or by the court. Okay? This is telling us, even though these are rules, in my mind, so long as it's not outside of the Constitution and the Bill of Rights, your right to a trial by jury is preserved, right? The right of trial by jury, as declared by the Constitution, or as provided by a statute, not allowed to codify, of the state of Idaho is preserved to the parties inviolate, right? Demand for jury. It's a demand. That's the title of your document, right? On any issue triable of right by jury. Well, according to the Constitution, whether it's criminal or civil, we retain the right to a trial by jury. If you're going to deprive a man of his life, his liberty, or his property, the right to a trial by ancient right of trial by jury shall remain inviolate. This, in their rules, are a fraud, right? Because the right dictates how the right works, not a rule. That'd be Miranda versus Arizona. There shall be no rule making that would abrogate the rights retained by the people. This abrogates that right by saying, on any issue triable of right by a jury by a party may demand a jury trial. It's not a demand of a jury trial, right? It's a trial by jury. Make sure you don't get that confused. That's their word salad, trying to trick you out of having to have 12, right? But at least 6. But notice it says, stating in such demand whether the party will stipulate consent to a jury less than 12 persons, but at least 6, the demand may be made by serving the other parties with a written demand. Everything must be in writing, folks. Got to create your court of record, which may be included in a pleading, no later than 14 days after the last pleading directed to the issue is served, and filing the demand in accordance with Rule 5D, which means you just got to file it with the court. Show certificate of service that you served it, and then go back in and say, yep, they received it. Okay. In its demand, a party may specify the issues that it wishes to have tried by a jury, right? So you're going to say, well, I got this, this, and this is what I want the jury to decide, right? So they know full well what the jury is going to be deciding. Both sides know full well, have full knowledge of what either side is asking the jury to decide. So no, it does not allow them to choose, Jennifer. The right of trial by jury as declared by the Constitution or is provided by statute stated about is preserved to the parties. The parties inviolate. Okay, you're in charge of your own affairs. Okay, these are private affairs, right? On any issue triable of right by a jury, a party may demand. When we make demands, it is inviolate. It is a demand. Plain and simple. There is no if, ands, or buts. Okay. Stating in such demand whether the party will stipulate. Okay. Well, I'm going to demand my right to a trial by jury in accordance with the Virginia Declaration of Rights. Okay. Of 12 men of my vicinage, without whose unanimous consent I cannot be found guilty. If I'm on the defense, but this is where I turn things around and say, well, yeah, you made false claims, that's perjury. Now let's go for some damages, because perjury is a felony. You're bearing false witness. You put it in and on the record, the court of record, under penalty of perjury. And I'm going to show you how to do that here next, but I wanted to show you these two things. Okay? Because this is right after the initial filing, right? Within a certain amount of time. Okay? 14 days. So you kind of got to be Johnny on the spot. Can't be derelict in your duties and expect to get justice. Lazy man loses. Okay? Whoa, wow, time flew. All right, I'm going to show you one last document here. What mine looks like when I did my responses in a family law case. Yes, minimize, you turd. Okay. Now, this is where you give rebuttal item by item, right? Line by line. For me, what I did was respondent denies all allegations of the amended petition pursuant to blah, 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 and demands, there it is, and demands strict proof of petitioner's claims. Now, I could change that to demands and requires strict proof of evidence or strict compliance of the rules of evidence. But this also is sufficient that I'm demanding the petitioner to prove her claims and supply sufficient evidence. And I would also do a separate document demanding the right to a trial by jury. And I do not consent to anything less than 12, pursuant to the Virginia Declaration of Rights and pursuant to the 7th Amendment. And then demand that everybody requires that I require strict rules of evidence. Now here we have affirmative defenses. That's the first part. So I claimed that my defense here is that the petitioner fails to state a claim for which relief can be granted. right? Because I'm denying all of her allegations, so we're going to go for dismissal because she doesn't have anything there that she can get relief granted. Then you have all these other things that are in there. Assumption of risk. Well, she took the risk, right? She's made several false claims against me under penalty of perjury. That's on her. Okay? Under duress. Here it is. Petitioner's choice of law and choice of jurisdiction was in error, which has deprived the father and child without due process of law of several fundamental, unalienable, creator-endowed natural rights and civil rights protected by, and I'm citing them, right? I'm making my claims here. These are affirmative defenses that she's not entitled to nothing. Here's the estoppel. Put a stop to this crap. Petitioners claim the respondent was banned from daycare is false. Trying to stop me from going into daycare. Then you get into counterclaims. Okay? Let's undo that. Counterclaims is where you give rebuttal to each and every lined item. Okay? Of course, you're going to say the parties, petitioner's natural mother, blah, blah, blah. You can even go far and say, I'm denying all of this, which, I denied one in the very beginning, right? Number one, respondent denies all yes amendment pursuant to ABB 3. Okay? So I'm denying all of it, which means she's got to prove everything, which she can't. She didn't. She failed. But we get down into right here. Start with the first one, basically, of her claims. And this is how you do this. The petitioner claimed that on such and such date, that at my home, that our son told her he got into trouble for his disrespectful attitude is false. I'm saying that it's false. Now, she has to prove it. And I say, in fact, okay, because I'm declaring my facts, no such occurrence happened. How is she going to prove that this happened when she wasn't here? She doesn't have any firsthand knowledge. Okay, this is a problem we're running into today's day and age, is people seem to think that they can just make these statements and it's automatically true. Yeah, if you don't invoke and require everyone follow the strict rules of evidence, or that I didn't rebut this on both accounts, this would still fly, right? But this is how you give rebuttal. Claim per claim, right? In fact, no such occurrence happened. Our son doesn't even know the meaning. I mean, this is just like common sense stuff. 3.5 years old then, okay? Further, in fact, father does not use spanking at all for discipline. In fact, father has only used timeout 3 times and hasn't had to use timeout for well over 6 months. Those are facts, my facts. And unless she can prove otherwise, kick rocks. This is how you beat them up. This is how you beat them up bad. But you got to do it just like this, right? I also threw in further in fact, pursuant to Idaho Rules of Evidence 514 A, C, and D, alleged statements are confidential and are not to have been disclosed, as well as Idaho Rules of Evidence Rule 801 is hearsay and inadmissible as evidence. Now, pay attention here. 514 and 801. Remember that? 801. What was that under that? Oh, stop. Back to those rules of evidence. I can show you exactly how that is. Oh, wait. Where was that? That was here. And here. Right here. 801 through 806 is the hearsay. And if you don't require strict compliance with the rules of evidence, hearsay is admissible. Right there. Do we get this trickery and how to get out of it? Or not necessarily get out of it, but restrain them from using fraud and fraud upon the court and getting away with it. This gets rid of all that crap. Should be the other way around, but this is the game they play. So, trying to teach you folks how to effectively defend your rights. Now, because of that hearsay, and that this is, I'm claiming that that's false, and I previously said that she's going to have to prove her claims. I said it's false, and here is the truth. And guess what that amounts to? That amounts to Idaho Code Section 185409, punishment for perjury. Perjury is punishment by imprisonment in the state prison not less than 1 or more than 14 years. That's felony. That's prison time. That's a $250,000 crime per instance, per person. So there's one. Okay. Number 2, number 3, there's 3 counts of perjury, 4 counts of perjury, 5 counts of perjury, 6 counts of perjury. I got 21 counts of perjury just in this response. You want to hammer somebody bad? Nail them with perjury. Yep, get out the clicker. Clickety, click, 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 click. Remember that clicker the school bus driver used to have? Every time one gets on, click, 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 clickety, click, click, click. That's what we talk about. Adding that stuff up. So that'll be good for tonight, I think, for episode 2. We'll get into some more deeper stuff on the next episode, next Monday. I may actually just start out like with a real, like a blank document and just kind of go through it again to show you how to do this in a little bit different manner with some other information that's going to be a little bit more powerful. And as I create it here, may just put it out there for people to have. I'm not wanting to put my own documents out there, so forgive me for that, but do some generic documents. So see you, Susan. Yep, we'll be on with Chris and John Wednesday and Friday. So if you'd like to help support me in my endeavors here, make a private donation, personal donation to me, the address for the office is on the page here, 6477 West Fairview Avenue, Suite C, Charlie, Boise, Idaho 83705. PayPal, my PayPal, if you want to do PayPal, you can directly PayPal me any personal private donations. That's Kirk_Pendergrass@hotmail.com. And thank you for those of you who made some more donations there. It was actually pay a couple bills that I needed to get paid. So back down to pretty much close to nothing. So trying to scrape by and get by here. So those of you that can afford to $10, $5, $10, $20 here and there would be greatly appreciated. Support me in my endeavors here, at least until I get some of my own lawsuit kind of stuff going on, and I'm going to teach you about petition and remonstrance and how to do your tort claims. And I actually thought I was going to get into the treatise on arrest and false imprisonment tonight, but that actually shows how to do the tort claims right in it. So we'll go through that next week. Treatise on arrest and false imprisonment. Teach you how to shut up. You don't answer any questions, right? I did, Alan. I did get that. Thank you. All right. Much love to you all out there. Thank you for tuning in tonight. Like, follow, and share. Get in here. Get that notification so when we go live, because sometimes we have breaking news or whatever. But other than that, our normal other shows are Wednesdays and Fridays, and I'm going to be doing this, going through our series here, episode 1 through however far I get. So that way, anybody new that comes in, I'm going to refer you to go watch episode 1, 2, 3 in order, so you get how to do this on your own. And if you got any questions after you watch the videos, then it may take some time to do that, but for the most part, should be able to answer most of your questions by watching these videos. That's why I'm spending the time right now doing them in a chronological order to make sense in how this all goes together. So much love to all you out there. Hang in there. Just want to put in a deal for John Gentry out there and his petition of remonstrance. It is now in the House and the Senate. So this thing's going. It's kicking off. It is going to happen. And if you'd like a copy of that petition of remonstrance that was filed and has now been presented to the legislature of Tennessee, both House and the Senate, you can download a copy of that from We the People, Victor50.com. It's on there now. I haven't got it into Kirk's Law Corner group yet. I believe Chris has got it in the E-Clause LLC group, formerly known as Amber and Stephen. Also, there's a page now that Chris has been going live from, just called Stephen. So that's where he's doing his little video stuff that I highly recommend going and watching the last one he did there. So that's all for now, folks. Much love. Have a good night. See you Wednesday.